Each transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in these sessions is relevant to the recipient's transaction or that the outcome thereof will be depicted as in these sessions. The discussion of ideas or procedures in these sessions is not exhaustive of the subject being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in these sessions, and the fact that the recipients may not be aware of these issues may have an adverse effect on the outcome of the recipient's procedure. It is the responsibility of the recipients to understand their own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto.
Top of the pile, so that the judge, like Jack tells you, it's LIFO. Last in. The last thing into the court is going to be the first thing out. Last in, first out. Does that make sense? And it's like so simple, it's unbelievable. Well, now this guy, he doesn't like that because, see, we're over here trying to get on this dang republic. He's trying to bring a republic. This judge is not against me. This judge knows his duty. His duty is public policy and to test and perfect me. If I'm not worthy of passing this test, he's not going to let me. We had that same mom on the young man that went to the mental institution. I was on the phone with her and she's, it's not fair, Gordon. It's not right. I said, why isn't it fair and right and just? She said, because he's trying really hard. I said, that's the words of a mother. Yes, he's trying for all he's worth. But you see, this judge is like fair, like you can't believe it.
All I see is the contract and the negotiations. I can't see anything else. I might like the guy, but if he doesn't contract and settle his case, I can't award anything to him. I'm here to settle the law. I mean the case. I mean the contract.
We talk about this. All of these courts are one thing: claims courts. The prosecutor came in with a claim,
which is a charge,
which is to demand or ask for as rightfully belonging or due to one. The fiction has a debt. He came in with a claim. Remember the statue that's in many court buildings with the blindfold and the apothecary scale, on the swing arm held aloft. A goddess of law and justice, daughter of Uranus and Gaia, her name is Themis, represented as holding aloft a scale for weighing opposing claims. There's a poem we talk about. Remember, we admonish you to substitute contract in the place of the word law. So listen to this poem doing just such. Once law was sitting on the bench. Contract sitting on the bench. Because there's going to be some contract there, a public contract or a private one. If it's a fiction, there is a contract.
See, the judge said to the defendant, did you get a copy of the contract? A copy of the charging instrument.
He asked him, did he get a copy of the charging instrument? Yes. Now, if our good friend, Prosecutor Richard, just before court started, he takes the charging instrument and he slides it over to me. Do I have it? I told you, you'd better not accept these sliders. You go to jail, slide the rule back under, slide the administrative hold paper, get it out of your hand.
Game is hot potato.
There it is. He says it. He's asking him, did he get a copy of the charges? Yeah. How do we know? Because he gave them to him, they came in the mail or something. When they came in the mail, when they got handed to me here, what I'm going to do with these? They're going right back.
If he returns it in the current state, he hasn't really resolved it. So if he had it and he's got a pen, even though it's only a copy and not the original, he's going to do a full acceptance on the copy and slide it back.
I'm just going to say, accepted for value, return for set-off, settlement, and closure. Thanks, brother. I'm not joking. On the back, if this is a check, how do you endorse a check, right? If the check reads like this, don't you turn it this way and put your signature across the top? Pretend this is a check. It just reads like this, right? So you're going to do the same thing. Throw your signature on it. Just sign it. Write it, but I'm just going to endorse it, and I'm going to say, accepted for value, return for set-off, settlement, and closure. Do you have any other charging instrument, bro?
Look at it this way. You got to
Now,
check.
what's he going to tell the judge when he said, did he get a copy of the charges? Well, what does get mean? Did I understand it? Did I get it? I think he got it. He returned them to me, Judge, and he did some gobbledygook on them.
See, when it comes to a check, remember the front side's the public side, the back side's the private side. Who's liable on the check, the endorser or the maker?
Remember, the maker is the one who made out the check.
Under the Uniform Commercial Code, the endorser, since he endorsed it, he is an endorser and he's now been made liable on the instrument. Absolutely. You have never, ever gotten any currency units from anyone in your life. Where did your currency units come from that you've been dealing with in your whole life? From your signature, and where'd they draw those units? Out of your asset account. You never knew it. If you work for General Motors and you got $1,000 paycheck and General Motors gave your straw man $1,000, because a living man does not work for General Motors. Only the vessel, the straw man, works. So they give us your straw man a check. You, as a living man, endorse the back of the check for deposit in whose account? The straw man's account in the bank, because you, as a living man, don't have an account. When the check goes into your straw man's account, where do the units come from that make that check good? Your account at the DTC. Did General Motors have any currency to pay you with? No. When the comptroller of General Motors wrote out that check, he said, well, if we had any currency in units, we would be happy to pay this contract off. But since we don't, we're just going to witness that he's entitled to this if there were any units to pay him with. So General Motors is doing nothing more than second witnessing that your straw man's entitled to it. But General Motors doesn't have any commercial energy. They're a fictitious corporation. What's the bottom line on their accounting sheet? What is the net value of General Motors? Zero. If there's any value there, there's a purported value to their stockholder. But every corporation bottom line on their books is zero, because they're a fiction. They're a nothing. They can't have anything. So the long and short of it is, your whole life, you've been paying yourself without knowing it out of your own asset account. Get that through your head. You are the bank. Nobody else is the bank.
And to keep it real simple, the phrase, my signature is good enough for you to understand, and that's all you really need in this general broad brush. Your signature is the money for you, all right? And returning it is critical, and that you don't keep any kind of anything from them. They'll always come and try and hand you something, because if you've kept it, you're liable for it. When you return it, endorsed, they're liable for it.
Anytime they hand you a piece of paper, they want to get paid. If you keep it, it's evidence you haven't paid it. So are you a debtor now or a creditor? You're a debtor. If you endorse it and hand it back, what's the evidence? You've paid the debt. I no longer hold it. Absolutely. A warrant in the government is a request for funding.
Request for payment.
We'll play that game later on. We'll send somebody out to arrest
break.
you, and we'll see what you're going to do.
Okay, let's recap this. We're going to get back into, we want to do some court practice, definitely. And we want to do some arrest practice. But these fundamentals, let's try and keep it. We got 4 doors, and we're not going to argue, and we're not going to make statements, and we're going to make conditional acceptances, and we got a hot potato we're dealing with.
Okay.
So you're going to have a little fun this afternoon.
Let's just bring up somebody. You're the defendant, and the judge has already done with his spiel. How do you plead to this case? Try your best to be Gordon in his response right now. We know you're going to screw it up. Just give it a try. Defendant right now has the floor. At this stage of the game, we want to know how you plead today.
I conditionally accept upon presentation of original charging or accusatory instrument for my inspection, so we can settle this matter now.
What are you, nuts?
You know, that's not a far thing. He could say, what are you, nuts?
Which is a question. How are you going to respond to the judge with that one?
You've been charged. How do you want to plead?
I conditionally accept upon presentation of original charging or accusatory instrument for my inspection, so we can settle this matter now.
What are you talking about?
Remember, we said his issue is to try to get you to explain. Do you want to answer his question directly, or do you want to demur back onto your issue? Okay, so don't answer his question, or else you become the defendant in his world. So try to think up a conditional acceptance response. You've got to address his issue. He said, would you explain what you're doing? Give us your response.
I conditionally accept your offer to explain upon condition that you provide me with a provisional our original charging or accusatory instrument, settle this matter for my inspection so we can settle this matter now.
Notice what he did. Did he go back to his issue or did he jump train to go over to the public issue? He stayed on his issue. Good job. Now we're going to give it a try.
Mr. Busher, you seem like a reasonable young man. Nice looking guy. I'm
Good
wondering
job.
where you're getting your information.
I conditionally accept my
On a
of
serious
information.
note, Mr. Nathan, we just need a little explanation because obviously you've been getting some kind of legal advice from somebody, and the rules of this court are really clear. And if you don't understand the rules here, you're going to get lost in this. And I might suggest that you get an attorney before you hurt yourself.
I conditionally accept your attorney upon presentation of original charging and accusatory instrument for my inspection so we can settle this matter now.
Okay, he's staying on the subject, but he's not really addressing the issue. He's not wrong. What would happen?
He
if
is
he'd
going to
come-
stay alive because of
Yeah, he
that.
is. What would happen if he'd come back and he'd say, I conditionally accept your offer on proof of claim that you're not trying to convert my remedy into some kind of jump the vessel back onto the train so you can deny me my remedy. That would work. You understand?
Or he
Because
might,
he's coming back to his remedy is I conditionally accept on proof of claim that you're not delaying these proceedings by obstructing the court by failing to give me the document to give me the remedy. He could do so many things, but don't answer that question. You see what we're saying?
Mr. Nathan, you really seem like a nice guy. You seem, and matter of fact, you're obviously very intelligent. They'll either try this part or flattery.
Or they might go
Yeah.
bad cop and warn him. They could do either game.
Okay, I've heard
Mr.
about
Judge, we've
enough.
got to adjourn for lunch or something here, or break pretty soon. So
I've heard about enough, and I've taken all I'm going to take out of you. If I hear that one more time, you will be held in contempt of court.
I conditionally accept your offer that you are not merely demurring my private remedy.
Bailiff.
arrest him.
Okay, now we didn't get into it a whole lot. We're going to close this now with this one statement. When you are now you heard Judge Smith say earlier, I may hold you in contempt. Judge Larry said, I will hold you in contempt if you don't answer my question or you say that one more time. And he didn't say that one more time. He said something else, so he's still safe. But I'm going to come back one more time and you don't answer me, I'm going to hold you in contempt. Answer him. He did answer him. An answer is a reply. But so that I'm not in contempt, we're going to close it with this. Think about this at lunch. Whenever you are threatened with arrest, contempt, or have the bailiff take you to the ground and sock you up, which isn't going to happen, so that I'm not in contempt of this court, I will say what you tell me to say. I will do what you tell me to do over my objection under threat, duress, and coercion. Judge Smith, whip it on me real quick.
Cannot have a contract under threat, duress, and coercion. Their goal is to obtain a contract from you. So that's the way this game is going. Okay, so I've already warned him and he's come back. Sir, I am ordering you right now. We're here for the purpose of entering a plea in this case. I want a plea out of you right now. I want guilty or not guilty, sir. And if you don't answer me, I will hold you under contempt. Is your plea guilty or not guilty?
So that I'm not in contempt of this court, guilty or not guilty, over my objection under threat, duress, and coercion. He said, you are to answer guilty or not guilty.
Whatever he said in the quotation, sir, you know what I'm asking you, and you're just mocking this court. Now, I'm going to give you 1 second chance here, sir, and I want an answer out of you because you're obstructing this court, wasting time. Are you going to enter the plea of guilty?
So that I'm not in contempt of this court, tell me what you want me to say over my objection under threat, duress, and
I
coercion.
want you to answer my question. You're either going to plead guilty, not guilty, or no contest.
So that I'm not in contempt of this court, guilty, not guilty, or no contest over my objection under threat, duress, and coercion.
Mr. Bailiff, take this man away. We will continue
I
this matter
conditionally
till
accept to
tomorrow.
be taken away on presentation of a genuine charging or accusatory instrument from my inspection.
I want him out of my
So
court.
we can resolve this matter now. Now, I'm not going to pull away. I might be trying to walk out the courtroom this way then, you know.
Okay, I didn't necessarily say he's under arrest. I said I want him out of my courtroom because he's given everybody in the audience way too much reality and information.
Okay, we're breaking. One last question by you, Kevin, and then we're going to lunch, get the mic, and then we out of here.
So as long as you continue to answer him like you did, he cannot place you under arrest?
No, because he's doing everything I ask him
Hold
to do.
on. He could remand you to see if you're going to break week, and we'll talk about that after lunch. So this is initial broad brush. There's exceptions to every rule, but we'll talk about it, and you'll find yourself very comfortable, and we're going to test some of you. All of you are going to be up here. All of you are going to play this game. All of you. So just get your mind into it. You're not going to get out of this.
And the issue is if you've got clammy palms, just playing here, think of what it would be like if it's in reality, because this play role is as close to reality as you're going to get. You're going to have to think like you were in front of a judge. You're going to be put in that process. And believe me, there's no difference between what we're doing here and in the court. If you could do it here, you can do it in the court.
It's not going to be difficult. It seems it at first, but watch how your practice goes. It's like playing hopscotch or anything else. Once we get you a few steps, you're going to go, hell, this ain't hard. It isn't. It's just new.
But obviously the people couldn't keep it. So since they couldn't keep it, it's like any other contract.
How does a government under the people come to be? And I'm wondering how the republic itself functioned. A private contract between individuals is clear enough, but how do you get large-scale cooperative ventures going under the republic? How did the government function before the Civil War?
It was a republic. It was a representative government of the people. The question was, in the Constitutional Convention, after that happened, the reason for the Constitution Convention was to, quote, create a more perfect government, unquote. The Constitution did not create the government. It was created under the Articles of Confederation and other documents. What is the purpose of a Constitution?
Well, that was a debt-oriented document. That was to
See, if you look up in Black's Law Dictionary, constitutor, don't look up Constitution. You'll never find the answer. Under a constitutor, it says one who passes on his debt to a third party. So what was the reason for the Constitution? Actually, the purpose of the Constitution was to create an Admiralty Maritime government on the national level. Remember, we said earlier that people's word is their bond. But if it's a corporation, an entity, or a person, it doesn't have a bond except that some other third party backs it up with an insurance policy. So remember, the District of Columbia, the national government, was operating internationally, not among the people in the states. And in order for the government in Washington, D.C. to operate under the League of Nations, it needed to have a surety to back up what was going on there, okay? And so literally, it needed the states to underwrite the national government as the insurers. Now, that's not what they told you, because the people basically were ignorant enough they wouldn't go along with it. They needed somebody to back up the national debt. And since the central government was international, they operated in maritime, not common law. See, they don't ordinarily send money payments between nations across the open seas as gold bullion. They use commercial paper to settle accounts. But if you have commercial paper, there's always the possibility of fraud and deceit. So they need an insurance company or insurance as a second backing in case somebody does not perform on their contract. So the purpose of the Constitution was to get the states to back the debts of the national government so the national government could operate in international commerce.
So I've never quite understood what the law of nations is.
It's private international law. That's where you ultimately get your rights recognized. See, like Gordon told you this morning, you don't need the government to guarantee your rights. Your rights are guaranteed by nature, nature's law, and the Creator. The fact that there is constitutional limitations is public policy, but that's not where your rights come from, so that's not what guarantees your rights. You have the right to access private international government maxims of law to show that there's been a pre-agreement among the nations of men that all men are entitled to these rights that are given out. But that means you individually have to be able to understand the procedure and the process to claim those rights under the correct provisions of law. So private international law, once the Constitution got inverted so that the public now became nothing more than a restatement of military government, the public assumes that you're going to operate as a maritime vessel to do your commerce. That's why they gave you a straw man. Your straw man is your vessel to operate on. And on private international commerce under the law of the sea, they've given you the tools you need to function. The patriots immediately object to that and say, well, our nation was created under the law of the land. We don't need a vessel. We can exist as a living man or woman. But remember, Hollywood is always telling you the truth. And Kevin Costner's Waterworld told you there's a presumption today that land exists somewhere. In other words, the common law. But according to the principles of the mariners, that's only a rumor that law exists on the land, that everybody is functioning on the high seas, and that there is no land anywhere. So now what you have is the public is actually believing this and upholding that. For instance, the geodesic survey of the land is conducted by the Coast Guard.
What?
And what does the Army have a mission to do? Dredge the harbors for the Navy. Are you getting the picture that everything's backwards and upside down here?
But does it
Because
really
we're
matter?
under the law of the sea instead of the law of the land. Now, you could object that, argue it, and fight it all you want. It isn't going to change the precept upon which everybody's operating. So you have to get your remedy styled through the presumption of the law of the sea, which is what those public courts are, but you're still maintaining the maxims and the remedy of law of the land if you know where to go get it. And in that movie that dealt with Waterworld, remember, there was a little girl that everybody was trying to locate. The little girl represents God's church. And what was it that she had that all the mariners were seeking? A map to tell you where the land is. In essence, she had the remedy that we're giving you to go back to your remedies of the Republic in order to put in shape your remedies coming from the law of the land. And then you've got to translate those remedies into the law of the sea and make them appear in the public maritime courts in order to get your ultimate remedy.
And isn't this a beautiful game? It's merely just contract law. You know, what about who wants the common law? Who wants this law or that law? How about just straight contract law and you get to be and do and make it whatever you want? It doesn't get better than this. It's not a bad thing. It's the best. It's merchant law. That's how you conduct commerce. You have to, and this law has existed for thousands of years. This same stuff we're dealing with now with some changes for the modern day communications and things like that, or addendums there too. So let's have some fun and learn how to play. It's not a hard game to play. It's just merely offer and acceptance and what constitutes agreement.
See,
It's that simple.
the sons of Cain have done in the secular law world exactly what God put out for you in the spiritual law world. In the spiritual law world, do any of us as sinners, I mean debtors, have a remedy to get rid of our debt in and of it ourselves? The answer is no. So what do you have to do to get a remedy in that spiritual world? You have to go to an accommodation party who's a creditor that has the currency to pay off the debt, i.e. the Savior. Okay? In the secular world, they made all you guys sinners. I mean, your straw man is a debtor, right? Does your straw man have any access to any asset currency to pay off the debt in the secular world? No. So what do you have to do for a remedy? You've got to find a savior that is not in the world of the secular debt. Who is not in the world of the secular debt? The living man or woman. You. You are the accommodation party. You are the savior for your own straw man. And so these people, you might call them brilliant. You might call them incredibly smart. All they're doing is copying the scripture. And whereas God put you in a world of spiritual debt and told you you had no remedy except to go to the creditor, They're doing the same thing to you in the secular world. In 1933, they took away your remedy in their world, and you got to go to an accommodation party from another world, which is the living man or woman, to get your remedy. That's all it is.
Which would you rather have? Pre-33 where you had to pay the debt, or post-33 where your signature pays the debt? It just gets better, you know? I mean, look at the bright side of this. That's not a joke. You absolutely have got it made. Never has it been so beautiful as it is today. We got iPhones in the world, and we got conferences. It doesn't get better than this. We're not riding horseback six days to get to this conference from Arizona. This is the time we've all waited for.
There's patriot gurus out there that tell you the government's wrong and do everything bad, and they can fill up an auditorium because everybody wants to believe them. But all of their remedies are on the moon. They're not working. And the reason they're not working is they haven't gotten to reality. Gordon and I come along and say, doesn't Scripture say you got into sin from the get-go and you have no remedy to get out of it? But the good news is you don't have to pay off the debt because there's a free payment coming from your brother, the Savior, that's paying off your debt. And you don't even have to pay it. All you got to do is go to your brother and ask for the remedy. It's that easy. Gordon and I say to our students, look, you've got the ability to move your hand and sign the name to a piece of paper, don't you? And if the answer is yes, you got your remedy. Doesn't Scripture say, basically, you weren't sold into slavery for money, and you don't have to come up with substance money to get bought back out of slavery. It's all nothing more than a monopoly game. But since the answer seems so simple, we get like 20 people that show up at a seminar because obviously that's too simple to work. The biggest problem we have is getting our students to understand in their mind that we're giving you something that is a substantive remedy. And literally, it costs you nothing except to wrap your mind around what it is we're telling you.
Now,
Most people can't deal with that.
you're going to find that we say a lot of things, and they sound good. Somebody emailed me the other day saying something along the line, if you don't read it, you don't believe it. It was something to that effect. And I'm going to tell you that if you don't crack a contract book and a few other books to verify some of this, you're going to have a hard time really believing it the first time a little wind comes in, a little water comes under your foundation if it's not set in bedrock. You can go to these contract books, Brian Blum's restatement. Brian Blum's book will tell you in the beginning, the study, if we tell you the game is contract law, is it merely then just a study of the rules? No. It necessarily requires careful thought about underlying policy, legal philosophy, legal process, and historical perspective. That means you got to open up a book. Just like we talk about the mailbox rule. It's deemed received. The court receives something when it's put in the mail properly, not when they get it. No, why don't you just be a repetitive creditor who knows what they're there for? A repetitive creditor who knows, hey, you got my money or don't you? Look, the dog's sick. You got my money. My mom's sick. My dad's sick. The kids all broke their backs this week. I just want to know, you got my money. Can you stick on your mantra to save your life? And then here's another one, ladies and gentlemen. What are you going to do if they say, remand her to custody? Now, you better speak up and do a conditional acceptance on proof of claim. They're not denying your right to due process and equal protection under the law, incurring personal liability or something. You know, you can do that, or just simply get your mantra, because they're very apt and they don't not do this. It wouldn't be unlike the judge in some of these cases to remand you into custody just to see if they could rattle you loose. And then we just had one the other day. They took him out of the courtroom. The bailiff said, you better knock that crap off. I'm gonna take you back in there, but one more outburst like that, and you're going to jail. He said, I conditionally accept your offer on proof of claim that my remedy can be considered an outburst. They took him back in. Just testing. You don't know that they're not going to do that. Do not lose the faith. You just hold up. You're not Mike, Gordon, Tom, Mary, Jerry, Jack, Larry, Sam. You're not a name.
Notice that one of the things we're doing on the conditional acceptance, have you noticed that we're doing things in the negative? Like on proof of claim that not something is happening. Why are we doing that? Why is it in a negative instead of a positive? Nobody can prove a negative. Now, understand this. See, in
Nobody can prove a
contract-
positive. You can't prove a statement. What you do with that negative is you put the onus probandi or the burden of proving onto the other party.
Removed
That's
to
the
the other
rules of the
party.
game.
Okay. In civil rule, I think it's 8 or 9 in federal civil rules of procedure. Most states are kind of copying that. It says that if in a pleading is an offer, if in a pleading somebody sets forth a fact by assumption or presumption. Remember how Gordon said this morning, there was a lot of things in what the judge said. He called you the defendant. He said there's charges, yada, yada, yada. There's a lot of assumptions there. They don't have to prove anything to begin with.
As prima facie evidence, remember, it stands as a fact unless refuted.
Okay, in the civil rules of procedure, it says that if you do not rebut a fact in a pleading, I mean an offer, it stands as consent of the parties. If you want to rebut it, you could argue it, but if you argue it, you're a debtor. It says what you need to do is you need to put it in a negative averment. And if you rebut the fact by a negative averment, you don't have to prove that you're right. It reverts to the other party now to prove the presumption. So you never want to be in a position of having to prove anything or testify. See, only debtors testify. Creditors never testify in their courts. So if the judge says, raise your hand, he's swearing you in as a debtor. You don't ever want to be in that position in their court because there's such a thing called a debtor's exam where you're sworn in. Have you ever heard of a creditor's exam in their court? Never. Creditors are never sworn in. So you don't want to have to testify. So if there is an offer against you, which you don't agree with, don't say, Your Honor, I don't agree with the assumption that I'm a defendant. Because now he's going to say, well, if that's your position, prove you're not the defendant. But if you put in a negative averment, I conditionally accept that I am acting in the role of defendant here today in contradistinction to an accommodation party. It's a negative averment. Now the prosecution or the plaintiff has to prove you're the defendant.
What did we say? She's going into court saying, I conditionally accept these proceedings on proof of claim that I am not here today as the paramount security interest holder. Being the paramount security interest holder gives her status and standing to protect the interest of the debtor because she's a creditor and she's got to protect those.
So if she says on condition that you can prove that I'm not here as the paramount holder. So if you don't think I'm the creditor, you prove I'm not the creditor. She's not going to prove she is. They're going to have to prove she isn't.
Can
you
they
understand?
prove? See, that's critical. You cannot make statements. We told you what arguing was. If you make statements, if you explain, if you justify, if you discuss, we're not here.
Your straw man is the beneficiary of that birth certificate trust that was created. You're going to see tomorrow that every benefit that you've had in your whole life, food, transportation, entertainment, everything hasn't come to you, the living man or woman. It came to your trust through the straw man. The straw man is the name of that trust, but the body is the corpus in that trust, and that body is named you.
When they're asking for the name, Jack, what is it they want?
They want to know who the trustee is that's responsible.
What is
for
the
paying
definition of who? Is it not what?
this.
Webster's
Correct.
defines who as what or which person or person. The judge says, what is your name? He wanted to know who you are. I mean, he wanted to know your capacity. And what is the capacity?
Well, the capacity in the Susie Taylor Trust could be the beneficiary who's the debtor looking for a benefit, Or it could be Susie Taylor, the trustee, who's here as the creditor to set off the charges. So there's two different roles that theoretically are in that trust.
Or another name
Beneficiary
for
or trustee.
another name for trustee.
See, the benefit is ownership, but ownership in this world is debt, isn't it? So if Susie Taylor is a secured party creditor, why does she want to be an owner of the property belonging to the trust Susie Taylor? A trust splits the title to the property. The beneficiary is the owner, I mean the debtor, and the trustee is the creditor. You want to go in there as the creditor, not as the debtor. Remember, didn't Rockefeller say the rule is own nothing, control everything?
Another word for own is to possess. Is generally when you own a car, is it in the name of your straw man so you think you own it? Big mistake. Wouldn't it be nice? You ought to see it. My boy we have one of his vehicles in a trust name. He says, man, I've been flashed 3 or 4 times, Dad, but I never get any paperwork. They don't issue tickets on these things. Own nothing, control everything. He's the manager of the trust. He gets to drive the truck. And what do you own anyway? It's just a temporary possession. We're leaving here. We ain't taking any of this stuff with us. So quit thinking it's yours.
Who does the government get to charge when a crime is committed? The fiction, which is the beneficiary. So if there's a trust and a straw man isn't behind the trust in terms of the trustee, they can only charge their own entity, their straw man. If your straw man doesn't appear in the trust, they can't charge someone that they don't have control over. You see what the difference is? You got to learn to go private instead of appear publicly.
But it doesn't matter. Jack is telling you, you're not a name. And I don't care whether there's a birth certificate behind there or not. A name is a name. It's a capacity. If you give a name, you're screwed. An accommodation party or secured party creditor is the capacity, here merely for the purpose. Remember, what's the subject matter? The parties, the venue, and the subject matter. Let the record show I conditionally accept these proceedings on proof of claim. I'm not here today in the private for this person. There's that, and venue. And now what's the purpose? To continue the public proceedings so I can finish the private administrative process so that substantive and procedural due process and equal protection under the law is applied. Can the judge deny the right of those kinds of things? Absolutely not. That would be a violation of law that he can't get around. So she'll put that into her mantra. What's he going to do? All she got to do is stick with it, and he's got to get her to unstick.
One other element, and then we're going to do some practice until a break, okay? The other element is reservation of rights. How many times have you heard patriots do the UCC 1-207, reservation of rights? Now, it's no longer 1-207. They revised the codes in the mid-2000s here, about 2005 or 6. They changed the number. So if you say, I'm reserving my rights under 1-207, guess what? There isn't a 1-207 anymore. So you come off being an incompetent boob because there isn't anything that you've just stated. It was re-put in as 1-308. Okay? It says the same thing. But the patriots always only cited half of that statute. They said, I'm here to reserve my rights. But that's not what the statute says. The statute says if you're going to reserve your rights, you can only reserve your rights if you do one thing. What is that one thing you've got to do?
Provide the remedy.
Provide the remedy as requested. So you go into court and they gave you a charging instrument, right? What have they requested you to do?
Provide the remedy.
So you have no rights unless you do what? Pay, which is why when they charge you, we do a full acceptance, which means I agree to pay. Now I'm reserving my rights. But sir, you're a debtor. You don't have any rights. I conditionally accept that proof of claim I'm not the secured party creditor that tendered the full payment, reserving my rights. See, they assume that if you're coming in as the straw man debtor, you can't pay, so you don't have rights. But if you come in as a secured party creditor and you've offered payment, then you do have rights.
That's just prima facie offer, a first offer. If you refute it or rebut it, it doesn't stand. And remember, what is a counter offer? A conditional acceptance is always a counter offer. A counter offer is a statement by the offeree. That's the person receiving the offeror makes the offer. A statement by the offeree which has the legal effect of rejecting the offer and proposing a new offer to the offerer.
Okay, so look what happens. They give you that original charging instrument. Do you want to do a full acceptance or a conditional acceptance? You have to do a full. A conditional acceptance says I'm not going to do what you asked me to do. I want to do it my way.
Now you could, there's certain kinds of things, but where Jack's talking about, this is a criminal case. Just endorse the back and hand it over for set-off settlement and closure.
When do you do the conditional acceptance? Once they come back and try to take away your original full acceptance from you. You understand what we just said? See, we said they always charge you and say, we want to get paid. You come back and say, I want to pay you on the private side. They go, we don't like that. We want you to pay us on the public side. Then you can conditionally accept their counteroffer to your full offer to pay on the private side. Because if you do a full acceptance to the offer that says we want you to pay on the public side instead of the private side, you've agreed to give up your claim and go back to be a debtor again. You understand? But if you do a conditional acceptance on the first request to pay, you haven't paid. You've objected to payment for some reason in your conditional acceptance. So therefore, under 1308, have you offered performance like they requested? No. So therefore, you have no rights and you fell back into being a debtor. So the first offer is always usually a full acceptance. After that, they're going to try to talk you out of your remedy, to which it's a conditional acceptance, and you keep coming back on your issue to pay them from the private side so you have a remedy. Does that make sense? Okay, let's do some role playing.
All right, let's get court started again here real quick. Thomas, come on up. You want to be the judge? Come on up. We need a court clerk and a defendant and all that good stuff. Ginger, you're going to be the bailiff. So we might have to have you arrest somebody. You wanting some action? Why don't you have a sit down, defendant Benjamin? Bailiff, keep an eye on this guy. Now we got Lewis, the court clerk. We got to have one more. Come on, let's go. We got the prosecutor. We got a judge. Now, you can slip into these roles pretty easily. So this is all for certain reasons. So what you're going to do, we're going to have the state of Thomas versus Benjamin. Case 1, 2, 3. Kevin, you're going to stand up as soon as they call that case and say, hey, Kevin here for the state of Thomas, prosecuting. And when he stands, you better stand right away too, right? And you're going to see, let's see how well you do. So let's call the case.
The state of Thomas versus Kevin, case number 1, 2, 3.
It's
No, we're
versus
not
Benjamin.
prosecuting the prosecutor. We're prosecuting the defendant, Benjamin.
Versus Benjamin. Case
Versus Benjamin.
Case 1, 2, 3.
Case number 1, 2, 3.
Hold on. What?
Ken, for the state prosecuting.
All right. You better speak up because, hey, Ken's here for the state to prosecute you. Put that up to your mouth. I conditionally accept these proceedings today.
I conditionally accept these proceedings.
Who are you, sir?
Conditionally accept these proceedings today.
Who are you? What's your role here?
See, this happens.
I conditionally.
Judge Thomas is cutting this man off. So, I
Don't
might start.
Don't keep going back to the same thing. He cut you off once. Going back to the same thing is just inviting contempt. So he asks you a question. So it's got to be a conditional acceptance, but it's got to kind of respond to what he said. Who are you?
No, I don't even have to respond to him. I say, excuse me, I'm speaking. When I get done speaking,
Could
Judge
do that.
Thomas, you'll get a chance to talk. I conditionally accept these proceedings today on proof of claim that I'm not here. This is why you want to try and be a little bit smooth on this.
Or he
because
could just say, I conditionally accept in the capacity of accommodation party in the matter of such and such. That answered his question, who are you? It was very brief and correct.
I conditionally
But
accept
now
on
we
proof of
got to
claim.
go on and you got to go back to your introduction.
I conditionally accept on proof of claim I'm not the accommodation party
For
here.
Benjamin,
For
may I proceed, sir?
See, there's 152,000 ways to do this. The important thing is you're not going to let Judge Thomas, and he did a good job. He just cut right off.
Okay. Watch what's happening here. See, when I told Benjamin to do that, Benjamin, the only thing he has to do here today is act like a creditor, right? That's all he's got to do. Everything else is on the moon. We don't care what the judge's business is. He's either a creditor or a debtor. Do creditors try to assist the court? Yes. So if the judge says, excuse me, sir, who are you? Oh, I'm a creditor. I want to help the court. Let's answer that question. I conditionally accept your question on proof of claim that as an accommodation party for Benjamin, I'm not here to assist this court today. Sir, may I proceed in my introduction? Now, is he acting like a creditor or a debtor? Creditor. Has he made a statement that was not a conditional acceptance? If he makes a statement, is he testifying? If he's testifying, is he acting like a debtor or a creditor? Debtor. So he doesn't want to say, I'm Benjamin. He doesn't want to say, I'm an accommodation party. But if he puts it in a conditional acceptance, how did Gordon define a conditional acceptance? It's an alternative issue before the court that's going to solve the problem. What's the problem? The judge wants to know, who am I dealing with? If he says, I conditionally accept that I'm not an accommodation party for Benjamin, has he assisted the court in resolving the issue? So now he's ready to proceed. Did he testify? No, he's acting consistently like a creditor. At no time has he acted like a debtor so far. That's all he's got to do. Your job isn't to explain to the court, you are here because they asked you to be here. You already told them I'm working on the settlement outside this court. I'm only coming to this hearing to get your acknowledgement that I'm here as a creditor, resolving this issue outside the court.
The judge saw this before he came on this thing.
Yeah.
Sometimes not. Otherwise, he's going to be asking for the charging instrument, but he's here to continue the proceedings, let's say. So
Let's say Benjamin says, why are you interrupting me? I'm trying to help you. That's a question. Now, ordinarily, creditors ask questions. Debtors answer questions. But Gordon and I warn everybody we're working with. There are questions that you can come out of your mouth that act like a debtor instead of a creditor because it's not resolving the issue.
let's see if
And
we
the
can get him in.
easiest one is mom says to Junior, take out the trash. And he goes, oh, mom, why do I have to take out the trash? My little brother gets away with murder. Why don't you make him take out the trash? Is this kid acting like a creditor or a debtor? He's arguing as a debtor, or he's articulating that he doesn't want to do something. Okay? So you got to watch questions.
So we prefer you stay with conditional
Yeah.
acceptances because you're going to end up in questions that are incorrect, that aren't leading to harmony. Let's see if we can. Now, Benjamin just stood up. The judge is talking. Ken's going to sit down because he's done here. But we're gonna start moving this forward. Go ahead, Judge Thomas. This guy just introduced himself. He wants to help and all that good stuff. But we're here for sentencing today.
Mr. Prosecutor, did you give the defendant any documents for this case?
You notice he's standing up whenever he talks to the judge. I'm telling you, when you talk to the judge, stand up. It's protocol. You'll see that the prosecutor does that. That's not a minor thing.
is operating under Robert's Rules of Procedure. Somebody has been given the floor to speak. When one person has been given the floor to speak, he has the floor until he is done and or surrenders the floor, okay? And if the judge interferes, he's in violation of the Roberts Rules of Order. He knows he is, but what he's doing is testing you to see how you're going to react. A creditor is going to apply Roberts Rules of Procedure in the court so that everybody gets his opportunity and everybody can conduct business and get his business on the record. Okay? The judge is free to do anything he wants to test you out because all he wants to know is Benjamin a creditor or is Benjamin a debtor? That's the only thing that court is doing today. Now, if Benjamin is a creditor, he's going to bring the solution to this problem sooner or later. If he's a debtor, he's delaying, he's obstructing, he's obnoxious, he's harassing, he's causing all kinds of trouble. So Benjamin is not here to solve the world's problems today. Benjamin is here to demonstrate that he understands he is a creditor and he can handle that position. That's it.
Judge,
Mr. Benjamin, could you take your hat off, please?
I conditionally accept to take my head off, Your Honor. Just keep my head off at the proceedings that we're going to
Well, do you want to discuss that or do you want to go back to your issue?
see, you might want to do, you shouldn't have come to court with your hat on and a toothpick in your mouth and whatever else. You know, there's protocol. Shouldn't you dress nicely? I would if I were you. A lot of people go in dressed like we are on the street. This is not acceptable court attire. Go in with
Not
a
as a
shirt and tie.
creditor.
Not as a creditor. You want to look nice. You want to look neat. If you got long hair, get the thing tied back, cleaned up, whatever. It doesn't matter. They got long-haired attorneys, this and that. That doesn't matter. But go in neat.
You did a good job, Benjamin, because you kind of demurred to his issue, but it could raise a discussion and an argument. So the issue, what you did is like what Gordon was telling Susie before. We're not here informally just to go through some discussion. We're here to conduct our business. So I conditionally accept your offer on proof of claim that is not the issue, the settlement of the case, and has this court not gotten my record of settlement, making your offer moot. Now, his offer
At the
was
same
to
time, I'd be
decorum.
taking my hat off.
Yeah,
you
I'd
know?
have been respectful. Okay.
But I'd be putting something on the record, and then therefore, my business here is concluded. I now move this court, or my business will be concluded. I now move this court to continue these public proceedings for 30 days so that we can resolve the matter privately so that we don't waste valuable public resources.
And there's nothing wrong with coming back and say, forgive me, Your Honor, I did not intend any kind of negative approach to this court or any violation of your rules as far as decorum is concerned, but I conditionally accept your offer now on proof of claim that we don't have the remedy here to resolve this matter, and that being done now, I intend to leave. See, there's nothing wrong for asking for forgiveness in case you have offended the court. Because when you go into somebody else's house or somebody else's business, when in Rome, try to do what Rome wants you to do. If it's merely procedural and it doesn't interfere with your remedy, it's not substantive. That's not a problem. But let's get back, Gordon, to the definition of forgive, I'm sorry, etc. What do they need to know about
We've
that?
talked about this many times. You know, what is like is not the same, for nothing similar is the same. So the words you use in law are very important. I'm sorry means simply, by Webster's definition, inferior, substandard. So when you tell the judge, I'm sorry,
Does that sound like a debtor or a creditor?
now the judge knows you're
Don't
sorry
want to be
ass,
that.
you know? You're inferior, you wouldn't be a debtor, and you wouldn't be saying sorry either. So he knows that. Apologize means what? To make a formal defense in speech or writing. I had an attorney when I was in prison. I was doing one for the guards on his divorce. And so I help the guards and inmates alike. And so I'm practicing law. I'm having a lot of fun. And we send off the attorney they gave money to a year before, and this guy hadn't done any paperwork for this guard. I said, not a problem. The attorney had the $3,500, never filed, never done anything. So we sent a demand notice back. She goes, she wrote back a letter to him and said, I apologize. My mother was sick, and made a formal defense in speech or writing. However, I'll now get on it. I'm filing it next week. I'm da-da-da-da-da. So he was kind of happy with it. Forgive. Remember, we told you that all of this stuff
In
is not to
essence,
do with.
apologize as a debtor because you're making a trial and an argument out of it. And we said to go to trial and argument is only something a debtor does.
If you're sorry, if you apologize, you're a debtor. Now, forgive, we talk about, it's all about claims. In latches, in estoppel, and in liens, in the definition of themis, in the definition of forgive, the word claim comes up. It's everywhere. Forgive is to give up all claim to punish or exact penalty for. And I don't say, please forgive me. I might get up and say, forgive my lack of decorum. And I conditionally accept these proceedings any further. I'll prove or claim we're not here. And I now move this court in accordance with the record to continue these proceedings for 30 days. And I've done mine. I do it. When I said forgive me, that wasn't a request. That was a command. Forgive me.
But it means you're bringing the remedy. So forgive is something a creditor does, but it's not, if it is a statement of forgiveness, if you don't bring the remedy, you're not the creditor. So you need two witnesses. Forgive means you're going to be a creditor. Prove it. Oh, because you go back to your issue of presenting your remedy. Now you can be forgiven of your faux pas because now you've brought the remedy as the creditor.
Remember what you're doing in court. You have to prosecute the case. If you don't, the judge is going to do it for you. So he better be on his game because the prosecutor's not going to be on his. So the judge is going to step in for the weaker party.
And to prosecute your case means to come in how? As the accommodation party and creditor to set it off. It doesn't mean you're representing. It doesn't mean you're arguing. It doesn't mean that you're bringing in a novation, just replacing one debt with another. It means you're coming in as the accommodation party creditor to actually zero and terminate that case. And remember, you're coming in as a secured party creditor to that straw man trust, which means you are the creditor. And if you just say, well, that's their straw man is their debtor. And so this has nothing to do with me. I'm out of here. Your real problem at that stage of the game is you've abandoned your post as the trustee over that trust. And if you abandon the post on trustee, if you don't make a claim as the trustee having control, then you've abandoned your claim, and the government is going to bring all kinds of hell down on that straw man trust because nobody's at the helm of the vessel.
Why don't we got 5 minutes left. Let's see if we can get through a couple of little things with Benjamin. We'll switch your spots. We'll switch up a little here. No, stay there, Benjamin. The question is, why are we asking for a continuance? The bottom line is we're just going to take that stance for this particular sample, okay?
Either remedy will do because you're going to provide the remedy. So
we're
either
just gonna,
way you can do it.
We'll keep it simple.
Another, we'll get into that.
Your mantra is, I conditionally accept on proof of claim. Is there not a request before this court to continue the public proceedings for 30 days? So, Judge, stand up, Benjamin. Rip off your last one again. I conditionally accept these proceedings. I conditionally accept the offer on proof of claim that we're not here, blah, blah, blah.
Condition.
Put it up to your mouth.
I conditionally accept the
offer.
This offer on proof of claim.
Is there not
a
request before the court?
Request for cancellation.
Is there not a request before the court to either adjourn or continue the public proceedings pending? I'll just help him out with this and we'll see how we do. And you bring Ken into this and let Ken do. We conditionally accept the offer on proof of claim. Is there not a request before the court to continue the public proceedings for 30 days pending completion of the private administrative process. Therefore, my business here will be concluded, and I now move this court to continue the public proceedings for the 30 days so that we can resolve this matter privately so valuable public resources are not wasted, Judge.
Kevin, Mr. Prosecutor, did you give him copies of the indictment? Does he have any indictments? And how did he plead? So
Excuse me, I conditionally accept the offer on proof of claim. Is there not a request before this court to continue these public proceedings pending completion of the start of the ongoing private administrative process? And on proof of claim, is there not a record before this court? Do we not have an agreement on proof of claim that we don't have an agreement with the prosecutor to continue these public proceedings? I now move this court to continue the public proceedings in accordance with the record.
has there been any agreement with the party? Do you have anything in writing?
Just say no.
Therefore,
We
let
can
the record show
conditionally
that the
accept the
defendant
offer.
has pleaded guilty to the
I
crime.
conditionally accept the offer. He says we don't have an agreement on proof of claim. If there's any record in opposition to the record that is before the court. Therefore, my business here will be concluded, and I now move this court in accordance with the record before the court to continue these public proceedings.
See, that's why it's important you have your document in the file of that court. That's the last in. It's in writing, it's a record. So what Gordon, the defendant, just said, see, the prosecutor is always going to say, no, we don't have an agreement. But remember, the only thing that goes on in court is the record in writing. And the defendant, I mean the accommodation party, he's got a record asking for time. The other party hasn't got anything on top of that record.
Now, Benjamin just asked a good question. He says, can I walk over and do what I just did? No, that was a sample, ladies and gentlemen. And that is a good question. You don't dare approach that bench without requesting, because that's a threat to the judge and can get you thrown
Your
to the
Honor,
ground.
may I give a copy of the record to the bailiff to bring to you?
That's presuming he doesn't have it. In some cases, like you heard Susie, she's got to get that PSIR thing down there. It's in the mail, but they may not get it Monday, right? Because it's up in Flagstaff, it's snowing, the mail might not do anything, might not even get picked up out of a mailbox till Monday. And it won't be there Monday afternoon. So she needs to carry some copies down with her when she comes into court. Court hasn't started. I'm coming into court with all my stuff. Excuse me, bailiff. I have a package here for the prosecutor, and I have one for the judge, and actually, the other prosecutor, Lewis. So if you could give those to for the hearing today and at 3, I don't have them. Could you give them?
And the bailiff will take it and serve it in the court.
There you go. I don't care if it's
These
served
are
5 minutes before.
These are courtesy copies because the real service is the thing that is in the mail, but they won't get it for 3 days.
Here's what happened when I went to court here a couple weeks back in Santa Monica. We came in, and you had to check in with the clerk there. So I came up to the clerk just right behind the bar, and I said, I'm here on the so-and-so matter. He says, just a minute. Hand me back all the docs. Oh, these are for the judge. He says, no. I said, problem. So I took them back, and I sat down, looked at these, put our names on it. One of our other guys came in. I said, now go take them back to the clerk. So he took them back to the clerk with our names, and he handed it in. The clerk goes, no, you take these. He says, it's okay, give them to the judge, and just walked away. About 60 seconds later, he got up, and he walked up to the podium and put them on the judge's desk. So your politeness, or what you think is being polite, is sometimes stepping into a debtor position. You got to be able to hold your contract. When I gave that, the bailiff is not going to give me any trouble giving package to give to the prosecutor and give to the judge, etc. The clerk might try. The long and the short is, that's that. We got this. They have a record, and I'm going to simply say, I conditionally accept on proof of claim. We don't have an agreement with the prosecution today, Judge. I don't care if that stuff just got to the prosecution a minute ago. It doesn't matter to me. Even if it wasn't even put in the mail, it doesn't matter. They got the record. Is there any record in opposition to the record that is before the court? Well, you just put it in 6 seconds ago. How could it be? So anyway, we have a lunch break. Let's wrap it up. We're going to come back and get on with some of this because you're all going to get it. We're going to go. We have to pound this a little bit. Yes. We've changed that up, and we're going to talk about when the mantra and this and that. And we're going to have a little discussion about that because you're right about that, Kevin. So hold on. Let's get a mic real quick. Thanks,
You
Judge.
said about the time.
Ooh, you got one. You don't need to get one.
You said about the time, the stamp on the time. Have you ever had it where the court has not took the stamp or changed the time on it? Because I've seen it before where the court would say, well, we got this February 16th or something, and you put yours on February 17th, and they change it and they put theirs on top of yours. Last on, last on.
They'll
whatever
play
said.
games all the time. The purpose of doing that is to get you to argue, because as soon as you argue, you're the debtor. I
But
told you, we don't care what the issue is. The only thing we care about is what kind of role are you going to play as a creditor or debtor. So if the judge wants to make a big issue about the timestamp, actually, if you're serving these documents, the things that are going into the clerk most of the time are notice services until we're ready to come in and
Rarely
finish
are
our
you ever
case.
going to see a judge. You're going to see them playing games with your timestamps. That's so rare.
They might not, but really your timestamp is going in by your third-party server, your notary, and he's more adequate at testifying at times than any of these people are in that court, because your process is outside the court. It's not in the court.